Welcome to, it's the 8th annual Thomas and Hafer General Liability Roundtable Conference. We've done this now 8 years in a row. Glad all of you can make it. Hello to you all in webinar land as well. My name is Todd Narval. I'm a lawyer with Thomas and Hafer. That's me. This is me. Gets confusing, I'm sorry. We're going to have an action-packed presentation for you today. The first installment is going to be about expert witnesses, but let me just put a pitch in for future wonderful educational opportunities involving this very same firm. We have the Employment and Labor Law Conference coming up on February 27th at the Country Club of Harrisburg. Only the finest venues with this firm, is what you're thinking, right? And then at the Country Club of Harrisburg, which is the same place, oddly enough. They not only have the same name, but they are the same place. The 6th Annual Claims Symposium on May 23rd. So all kind of educational opportunities, all kinds of fun speakers, and all kinds of frivolity. We're going to have 4 hours of stuff today from the podium here. It's going to be people talking, imparting helpful information to you, we hope. But in an effort to make it more enjoyable and more interactive, please feel free to raise your hand and interject at any time. Everybody's prepared to field questions, field ideas. Some of the best thinking happens when a lot of people are doing it in concert. So that's something we encourage you to do. So speak up if you have something you're going to say. Maurice, in your case, try to do it a little less. Our first installment is working with experts in engineering, engineering experts in litigation. We have Joe Cardile from our Maryland office is going to participate in it. And also with him is going to be Gavin O'Hare, who's somewhere.
Right here.
Where'd you go, Gavin? There he is, over there. Sorry. Gavin is with CED Technologies, and he is a graduate of the United States Naval Academy. So we, it's common parlance and courtesy to thank you for your service, but that is very impressive that you're a Naval Academy graduate, and no pressure. Entertain us, sir.
All right. Well, hopefully we'll do something on the football field against Notre Dame this weekend. Got great expectations out there. Do you want to stand on that side and I'll stand on this side?
Hey, Todd, can I give this to you? I'm going to use this portable one. How's the video? Can you hear me okay? All right. Thanks to Tony for arranging my tie accordingly so I can be heard. How's everybody doing? All right. What Gavin and I are going to talk to you about today is working with engineering experts in litigation. Really what I mean by that and what I'll be talking to you about is, we'll break it down a little bit more than that. It involves a broader scope. I'm going to be talking to you about using engineering experts in the investigation stage during inspections. And then using engineering experts during, as a trial consultant. Do we file suit as a sub-row? Or do we make a decision to defend or settle a case? And then finally, I'll be going into more detail about how to best use an engineering expert, or experts in general sometimes. Use them as tools. They're there to be had, and I'll be getting into a lot of detail on that, is how we can use them for depositions to better prepare us for trial. Gavin's going to talk about who CED Technologies is, what it is. Essentially, it's a company, and Gavin is going to go into more detail about this later on. It's a company that retains expert witnesses, specifically engineers. That it's kind of a one-stop shop. We can go to it, give Gavin a call. He can point you in the right direction based on the facts of your case. He can tell you who you might need, whether it's a mechanical engineer, an electrical engineer, or so forth. And he's also going to talk to you a little bit about the tools that they have on hand to better help the people who are helping you. So without further ado, where?
I've got the clicker
The
here.
clicker. Hit me two ahead, please. I just went through our agenda. So now we will talk about why and when.
Sorry.
We'll talk if.
Okay, there we go.
Can somebody maybe help Gavin get that ahead? And then meanwhile, we'll talk about why and when engineering experts are needed. I've broken it down into three categories, what we just discussed a little bit earlier. For investigations before litigation, as a consultant in making a decision whether or not to file suit, a subrogation suit or to defend a suit, and then in litigation. Just to get into a little bit of detail, when I say pre-litigation investigation, I mean during inspections, when something first takes place, kind of like a first responder situation, right? If we're lucky enough as a claims adjuster to get a claim the day after the incident happened, or maybe the day of, or within a week, maybe the evidence is still there and still preserved and in its natural condition. It makes sense, and it's very helpful to get an expert out there, whether it's an automobile accident, maybe the brakes of a car failed, or a furnace caught fire, burnt down a house, or a balcony collapses after that's related to a construction project. We want to get an engineer out there while the evidence is in its best condition, so that it can, the engineers can get the best analysis and conclusions out of that evidence. It's also beneficial to get an engineer or an expert out there right away because it gives them credibility. They see it at first. Again, the evidence is in its best condition, and then they continue to see it as kind of its life goes on and it results potentially in litigation. And when the expert ultimately gets involved in litigation, he appears better before a jury, having seen the evidence a day after the incident occurred, having inspected the furnace the day after or a week after the incident occurred. It gives them better credibility.
Joe, I might add to
sure.
that. So oftentimes usually we'll be retained by counsel or claims folks, and it's not fresh, okay? It's not a rapid response scenario. So we will always reiterate what Joe just said, is getting out to the scene, seeing the evidence. It oftentimes helps us uncover things that you can't get from someone else's pictures, okay? But that credibility thing does matter. But the benefit to doing a rapid response is huge, because you're seeing that evidence sitting in the state that the collapse occurred or something like that. Now, in the audience here, how many folks do send out experts rapidly to respond? Okay, a few of you, good, okay. Yeah, so that's good. We're preaching to the choir to you folks then. Sorry, Joe.
It's rapid response. Situations involving rapid response also have benefits of sending an expert out, because it does what? It helps preserve the evidence. The expert examines the evidence, maybe makes a recommendation to you that, hey, you sent me out. I'm an electrical engineer, but maybe you want to get a mechanical guy out here as well. Experts can recommend getting them out early, can make sure that you have the right experts out there. Those right experts can hopefully preserve the evidence, so that you're in a better position, whether you're filing a subrogation case later on or defending against the case, that you've got the correct analysis and you're looking at the right evidence. In making determinations as to whether to file suit as a subrogation lawsuit, or you get a claim and you want to know whether you should put money and time into defending it, or settle it because you don't really have a shot. Experts are great resources, and you should rely on them in making that determination. If it's a furnace fire again or something, you're talking to an electrical expert. He might tell you that, hey, you've got a good shot at this case. The evidence is good. I believe in my theory of the case, so go ahead and file suit. It might be worth your money. Or go ahead and defend the claim. I think you're going to get a good result of it. We've got good ground to stand on. Or save yourself the money. While there's some evidence in our favor, the likelihood of the other side poking holes in our theory, or our theory is not the strongest, save yourself the money and settle the claim earlier on. And then finally, and I'll talk about this a lot later, but the popular notion is that experts testify, right? they go to trial. It happens very infrequently, but when they do, it matters. So the third and final area where you can get an expert involved is at trial. Suit's filed, there's a scheduling order, you designate an expert witness, he helps you with discovery. So an expert in litigation he's also going to investigate. Maybe he investigated as a first response scenario, or he investigated evidence that's 2 years old. I'll get in a lot of detail about this later, but educating the attorney. One of the reasons why this presentation was attractive to me was because it enabled me an opportunity to get up here and talk to you about claims adjusters and attorneys, the importance of of not just letting an expert do his job and relying on that job, but learning the expert's job, learning what he knows. I don't want to get into this too much now, but let the expert educate you, whether you're a claims adjuster, whether you're an attorney, because it's going to help you settle your case, or it's going to help you make a better determination on defending a case, whether it should go to suit. And the same thing as an attorney. You're going to have a better opportunity and know your case better if you listen to your expert. You can jump ahead.
I was just going to add to that, when you select your expert early on, pre-litigation claim, hopefully that's the same expert who's going to go all the way to be your expert witness, because there's an efficiency of that person saw it, they documented it. But what happens oftentimes when you hire good counsel like the folks at Thomas and Hafer, they might say, well, actually, I think I need a better, or a different expert. And unfortunately then, now you're forced to spend more money to get that new person up to speed on what's transpired. And ultimately, they may not have seen the evidence, so some of that credibility goes away. But these are considerations that you have to deal with up front. And we're going to talk about, I'm going to spend a little more time talking about experts later on. Here, if I can get the page to move forward. Okay.
So now we'll talk about, do we need an expert? How do you make that determination? You get a claim that comes across your desk, it's a balcony that falls, or it's an automobile accident. Do I need an expert? How do I know that? You jump ahead one, Kevin. In Maryland, and I think this analysis applies in all states, but the standard for admitting expert testimony in Maryland is whether or not it's going to assist the trier of fact, the judge or the jury, in understanding evidence or determining a fact and issue. So in other words, the standard, as I read it, is does what you need from your case, if it's a case in litigation or if it's a case at the investigation stage, what are the facts? And looking at those facts, are they facts that lend themselves to something that I can figure out as a claims adjuster, or my friend, my neighbor across the street would probably have common knowledge of? Or is it something that somebody probably had to go to school and get an education on? I think that's a simple way of looking at it. Whether it's an if it's a battery that fails, or a heater in a car that catches fire. I don't think me or Steve across the street can probably have a good idea and be able to put our minds into figuring out the problem. That's the first key that an expert's probably needed. If you can jump back, Kevin. Back two now.
Come on.
There we go. And again, you also want to take into consideration what stage you are at. Are you at the investigation stage? Or are you already in litigation? If you're in the investigation stage, you're going to rely on the claim as it's been reported to you. If it's in litigation, you're going to rely on the facts of the complaint. What's pled? What's the language that's used? And that's how you're going to determine whether something caught fire, or whether a car just went through a red light, where you probably don't need an expert. You jump two ahead. So, actually, I'm all over we'll jump back. I'm going to go back to Maryland Rule 5702 quickly and look at this language down here. Is this a pointer? Whether a court shall determine, number one, whether the witness is qualified as an expert by knowledge, skill, experience, training, or education. It's great advice. And it makes sense. When you are determining that there's 1,000 electrical or civil engineers out there that you have to choose from, who's my guy? Who's my girl? Look at their CVs, look at their resumes. You want to, because the court's going to look at, when you get to trial, the knowledge, skill, training, and experience as a criteria to admitting that testimony. If that testimony doesn't get admitted, you just wasted $30,000, $35,000 or more from an expert at the investigation stage all the way through litigation. You want to get that testimony admitted. You want to make sure they're qualified. You want to make sure that they have testified in the jurisdiction that you are in, that they've testified on similar or the same scenarios before, and that they've been admitted, their testimony, and they've been admitted as experts in those jurisdictions on those issues. These are questions that you want to ask in determining who is my person. Prior working relationships, it's a great way to figure out what I just talked about. Whether it's a claims adjuster or an attorney. And if it's a claims adjuster, if you don't have the answer, call an attorney. Because an attorney likely has a prior working relationship with mechanical engineers, electrical engineers. They've needed them in cases. Prior working relationship is invaluable here because you already know the knowledge, skill, training that's seen on their resume, on their CV, but you've seen it in action. You know how they react. You know if the expert is responsive. You know if the expert's easy to work with, if you get along with them, if he produces good reports, sound written reports with sound conclusions that are free of grammatical errors. And you know if he's testified, and you know how he testifies and how he comes off to a jury, how he speaks to a jury. Prior working relationships with a claims adjuster or an attorney is an invaluable asset in order to know, in determining whether or not you've got the right expert. Again, their ability to testify, how they help you in depositions, we'll get into that later, but prior working relationships, in my opinion, from what I've seen, are invaluable to selecting the right expert. So now I'm going to turn you over to Gavin, and he's going to talk to you some more about CED technologies.
Is it working?
What it does. It might have like an 8-second
Why don't you
delay.
hold on to it? I think it works better
Okay.
over from that side of the room. So thank you, Joe. What I'd like to talk to you about is a company who staffs itself with forensic engineering experts to support you folks and ultimately counsel. And I have the bias of working for this company, but I'm going to tell you what we do so that perhaps I can raise the bar on your expectations of your next expert that you retain. So a little background, you heard, I'm from the Naval Academy. Well, no surprise, our office started in Annapolis, and so many of our engineers do have a military background as well. We think that's perhaps, they've been in industry, they've had the military, but perhaps that's a different bit of credibility that they bring to the courtroom presence. But that's for you to judge, I guess. Started about 31 years ago by Dr. Clyde Richard, who was a mechanical engineering professor at the Naval Academy. And then that's the map of where we have offices now. Yes, we do have an office in State College, Pennsylvania. And the guys there, actually one of the guys is faculty, but the other guy is not an alumni of that fine institution. So we struggle with that a little bit. Next slide, please. Oh, maybe it doesn't like you. So I won't spend any time on this, but this is basically a matrix of the engineering disciplines and where we typically work, whether it's product liability or premises liability, things like that. And I've left some brochures outside by the front table if you want some more detailed information on our company of engineering experts. Next slide, if someone could get that.
Okay.
So this slide, I think, is very important. Again, it's the bias that I have representing CED. But whether you call us, whether it's a rapid response or a claim investigation or counsel calls us, we assume it's going to trial. So we build some quality control and attention to detail into our processes the whole way through to make sure that, just as Joe said, the expert testimony doesn't get thrown out, because that would be a very bad thing for you and for us, quite frankly, to have that black eye. So when we bring a younger guy or a newer guy to the forensic industry in, there's a bit of an apprenticeship that happens. The guy is mentored by a more senior engineer and goes through and does his first few inspections with someone else. Before his first deposition, he'll get tried by our own people. We call it a oral board, if you will, some of the things we used to do in the Navy to make sure that the person was up for their next position of responsibility. Managing expectations is huge. Council calls us last minute, you know, I need a report in a month, so sometimes it's a short fuse type scenario. We have about 50 employees in the company, so we can put multiple folks on it if needed. But managing those expectations and the demands of the case, we have to meet those. And if we can't up front, we both need to know that so that we go in different directions. For the claims staff, oftentimes they'll go, okay, go out and do your inspection and then give me a report. Well, sometimes we provide some training in that regard because what we find in that inspection may not be good for the insured. So we go, hold off, I don't think you want this written down, I'll give it to you verbally. So the default is a verbal report. But should the written report be needed, and certainly it would be by counsel, you know, in the legal process, our report has a technical reviewer, a peer review, if you will. So one engineer is doing most of the work typically, but another guy or gal will be at the end to go, okay, what did you look at? What were you given? Yeah, you can make those opinions. So it's a quality control we try to build into it. When we go to deposition or trial, we take our whole file and we organize it very well. We put tabs in, so instead of scratching our head, what was the opinion, where was that? It's right there. And so it's very organized, professional, and it helps us come across as a very credible witness and prepared and thorough. Because, as I said, we are mindful of Daubert. That's something that none of us want to have happen to the expert. Next slide, please. Okay, very good. We talked a little bit about this initially. Rapid response, it's the best case scenario. I'm not going to beat that horse because I think the folks who raise their hand, who do rapid response, they recognize that evidence deteriorates with time. And I've listed a few things here why it would deteriorate with time, whether it's marks on the road by first responders, police and such, or it's equipment that might have been sold or modified or serviced over the years, and things change, okay? So when we normally get involved, because statute of limitations comes and defense counsel gets involved now, it's not rapid response. And we still, that's the majority of our work, but this is the ideal scenario. Next slide, please. So site inspections. That's Bob Miller in my office in Annapolis, another Naval Academy grad doing his inspection. I brought a few props here, and I wanted to pass them along. Bob is probably measuring some crush, which what a mechanical engineer will do is they'll take the damage, the deformation of the steel, and they'll be able to back that out through science and come up with speeds and directions of vehicles. Pretty cool stuff. That's the ultimate accident reconstruction. As an engineer, he can do that. Oftentimes, the state troopers or police that go into this industry afterwards, they can't go too far into that engineering side of it. So again, that decision you make up front on who you're going to get involved in looking at the evidence, it may matter down the road when counsel gets it and they're trying to figure it out. But here's Dr. Richard with the original selfie, and I'll just pass this around. It's kind of funny, but I'm going to show you some tools that we use nowadays. But this was Dr. Richard with a big stick and a camera and looking down with some measurement tools to measure crush. But when we do a site inspection, obviously we're trying to document the evidence. We'll take measurements, photographs, video sometimes of operation of the equipment to confirm that it does operate as it was supposed to. Before we go to any group inspection, all of us in the room, need to make sure that there's a protocol. Because if you don't have that, then it's going to take a lot longer, and that's going to be a lot more of your money. So we'll always remind you, if we're not the lead guy or person for the inspection, we'll say, is there a protocol for this? Because otherwise, it's going to take forever. And sometimes if we want to actually get an exemplar, let's say it's a fire involving a toaster or a power strip. Well, if we get our insured's product and we can open it up, we know what kind of tools it takes, we know what it looks like inside, then when we get to the inspection, we have the right tools, and we know what it looks like inside, and so if it doesn't look like our stuff, then we can say, oh, we're out, it's not ours. So having that exemplar in advance to some inspections can be very helpful. Next slide, please. Testing the theory. You want to play that video in the video number 1, I guess it is. This is we're engineers. We love science projects, okay? So the ideal case for us is where we actually go out and do a science project. So this is Dr. Richard behind our building in Annapolis, and he's dealing with a case where the plaintiff used a post driver, which is on the ground right now, and the plaintiff says, when he was using it, it bounced off and struck him in the head. And Dr. Richard said, that just doesn't sound right. So he did some initial testing, and then he ran it by our client, the attorney, and said, I'm going to do some testing. And I think at this point, when we did this, he was a trial consultant, okay? He wasn't designated, because what he might find when he does this testing might be bad for the case, okay? But what he found was good. And he literally tested it, and it's a longer video, so I'm not going to show the whole thing, but he goes out and does it, and he shows that it couldn't have happened the way the plaintiff said it did. So sometimes, you get these PhD mechanical engineers, and they're really just doing some simple testing to confirm things did or did not happen the way they said they were. So can we get back to the PowerPoint? Thank you. And we'll go to the next slide. I'm going to talk about a few disciplines where engineers in our shop do their work. One is fire and explosion investigation. One of the trends we're seeing nowadays is that even though the expert does good work and follows the NFPA 921 methodology of fire investigation, the fact that they didn't have the merit badge, if you will, the Certified Fire and Explosion Investigator credential qualification, then the other side throws them out. So when you call our shop and you say you've got a fire or an explosion, you are only going to get someone who has that qualification, which is designated by NFPA 1033. So be aware of that, okay? But what are we trying to do? We're trying to figure out, is it a manufacturing defect? Did someone touch it? Did they alter it? Was it serviced? Did somebody sell it? Or was it the user, Anybody know what that is, the picture? Kerosene heater, kerosene being the key word. Dr. Richard, many years ago, went all around the country for defense counsel because when you put gasoline in a kerosene heater, it works real well for about 5 minutes, and then you walk away and you come back and it's an inferno and bad things happen. So anyways, that's a fun little story there that we did a ton of work on those. Not so much nowadays anymore. Next slide. How about human factors? You guys get involved. The lawyers probably see those in some cases. How about claims folks? Human factors, in this sense, it's talking about the hierarchy of design or safety. Okay, this is a heavy machine somewhere in central Pennsylvania. Guys cutting metal, steel, and when you put a body part where you shouldn't, bad things happen. Okay, so what you try to do is you try to make sure that the machine is safe, inherently safe. Well, if it's not, then the first factor is design, safe. Then you try to guard out the danger. Okay, and the next human factor is warn of the danger, and then the warnings is there's a whole litany of standards associated with warning label design and all that, and experts can speak to that. And then the next layer down is training, but you can only do that in a commercial environment. With a consumer product off the shelf, you can't train the consumer to use it. But usually what happens in human factors cases, and this is my word, not being an expert, is the idiot factor. It's stupid people doing stupid stuff and getting themselves hurt. And, but that's human factors in heavy machinery cases, and there's still a bunch of those. Pennsylvania's got a lot of that industry still around, so if you haven't had them, I'm sure you will. Next slide. I talked about the warning labels. Yeah, you can see it. There's warning labels everywhere. Anybody play golf? Get on a golf cart? My gosh, warnings everywhere. Buy a ladder from one of your big box stores, warnings everywhere. Okay, but there are ANSI standards for that, and experts can opine upon those things as to would they have been seen, would they have been heated, all that good stuff. But again, that's the weaker of the cases in a human factors type case. Next slide, please. Vehicle crash group, that's what we have within CED. These are folks who typically are mechanical engineers who do accident reconstruction. We can also download, it's not actually a download of the vehicle's EDR engine data recorder information. What we do is we plug in to underneath the steering column of a passenger vehicle, and we can get an image of what the data is. There's, per federal standard, I think there's 32 pieces of information that are gathered. Things like, was the accelerator depressed? What was the speed? Was the brake depressed? Was the seat belt fastened? All those things. And it's typically a few seconds before the event and a few seconds after. Okay. So they do those things. Vehicle fires are a little different from house fires because you have to understand the engine in a tight compartment and all the things that come into that. Human factors in the vehicle world is more of conspicuity, what people can perceive and how they can react when the pedestrian goes underneath the vision of somebody driving a dump truck, for instance. That's a conspicuity issue. Biomechanical engineers opine on injury causation. Anybody ever work with a biomechanical engineer? Yeah, they're great. They serve as the bridge between Bob Miller doing his accident reconstruction and telling you that these are the forces that acted on the vehicle, and the medical doctor saying that this is the injury this person has. The biomechanical engineer serves as a bridge between, these forces are consistent or inconsistent with the injury the person has. So you might want to consider biomechanical analysis on certain cases. So that's our vehicle crash group, and I imagine everybody in the room has dealt with vehicle work in some fashion over the years. Next slide. That's the machine we plug into. You can see starting around 2001 is when airbags were regular in vehicles, and that's why this information is now readily available, because it's tied into the airbag system. And the manufacturers, for the most part, let us do this. A couple of ones that are tricky are Hyundai and I think Subaru, maybe, unfortunately. So this kit will not be effective with getting that data.
If I can jump in on that one,
please.
Kevin.
Yeah.
I've had a couple of automobile accident cases, and these crash data retrieval, is that what the CDR is?
Yep.
They save a lot of time. They can save you a lot of money. They can save you a lot of money in defense costs. I think Toyota's might have been the first manufacturer that came out with the CDRs. I don't remember what year it first came out, but I've had a number of Toyotas where I've got an insured, I've got a client telling me that he wasn't responsible for the accident. There's a lot of injuries in this case. And he wasn't responsible for the accident. He says that he did hit the person in front of him, but that person slammed on his brakes because that person was angry at him, and then it resulted in a chain reaction of the plaintiff in the first vehicle getting hit and sustaining the injuries. CDR is pulled from the vehicle, and it shows the complete opposite. Okay, it shows where the impact occurred first. It shows that the impact occurred to the rear of the middle vehicle. It shows that my guy it shows the speed at which my guy was going, that he was speeding, he's driving a tractor trailer. It shows that the impact and the likely speed to the first vehicle. It saved us a lot of time in litigation. Now, we accepted liability in the case, but it was before we expended a lot of money on experts, on depositions, and in going through litigation, because we utilized this technology. And it was it's an example of when to get an expert involved and what they can do for you. And in addition to providing testimony and helping you with your depositions and going to investigations, they can get technology from vehicles that'll streamline the amount of work that you've got to put in cases, and save you from potentially large verdicts.
If I could jump in, I'm going to probably say this again at the end, but if you call us early, we're not going to start charging you for our time. We're going to have a conversation and manage your expectations. But some of that might be what year is the vehicle? What's the VIN number? Is it covered? What's going to be the cost associated with getting that data? Okay. On a tractor trailer, those are more sophisticated black boxes, and they don't overwrite themselves. Okay. On your normal passenger vehicle, it may, if it has another event, it may erase and write over that information. So obviously, capturing it soon after the accident is ideal. Okay. Now, this is typically a decision that folks in the insurance world can make. but may choose not to. So I would suggest that if you have a risk criteria out there, a threshold, that you think it's going to litigation down the road, you probably ought to make the decision to spend a few $100s to download it, okay, to capture it. If it's a personal injury or property loss that is up there for you, then make that decision early on so that Joe's not saying, darn, we don't have the vehicle anymore, it's gone, or it had another accident and it's been overridden. So I know that's a cost that you may not want to do up front, but if you think it's going to be a big enough thing, then you got to make that call early on and help us all out. Next slide, please. Crush measurement. The pictures going around, and I showed Bob Miller down there. This one's a funny picture because it looks like there's no damage to that bumper, right? Well, if you go to the next slide, you'll see that we've got a comparison of the top graphic is a virgin bumper, not damaged, and the lower one, you see some slight deformation. And that's the steel bumper underneath the veneer on the outside. So by just taking a picture, there's no damage. Well, actually, there is damage. It's inside, and we can back that out through accident reconstruction and determine the speed and direction of vehicles as they came together, which can be critical for your case, obviously. Next slide, please. For time concerns, I'm not going to show this, but I've got a video clip of surveillance. And surveillance is key for premises liability. It really, oftentimes you don't need experts because it's right there. But this is a case where a lady walks through, she comes back 5 minutes later, she gets some oil and pours it on the ground, comes back 5 minutes later and like dives in like she's going for home plate. And so then she's got injuries that would be inconsistent with the way she said she fell. And there it is, it's captured on surveillance, and so they don't even need experts. But keep an eye out for surveillance video. It's everywhere, right? I mean, if you're not searching that out, you're missing out on some juicy information there. Next slide, thanks. Construction. So our guys and gals in the construction world, we do everything from construction defects to stormwater management, flooding that may happen, to workplace accidents. In Philly, there's 1 million defendants when there's a construction workplace accident, and so we keep very busy with the workplace accidents, dealing with OSHA 1926, 1910 for general industry, and there's just a laundry list of things that we could do for you guys as civil engineers typically, but oftentimes mechanical engineers can also opine on construction type accidents or construction defects. Any comments or questions on thus far? Okay. By the way, we meant to say this up front, but if you do want to stop us, please do and ask a question or give us a comment because this is for you. So, next slide, please. At the end of the day, you want your expert to have their opinions based on a standard or code or law as their foundation. Because if they do not have that, then the other side it's going to make it easier for them to pick away and say, well, why are you making this opinion? So we will always try to base our opinions on one of these things or other standards. Sometimes there's nothing out there, but this just makes us more bulletproof. So demand that from your expert, and when you're talking to them up front and managing those expectations, ask the hard questions. Are there standards that apply here? And if there aren't, beware of Pandora's box later on. Next slide. Yeah. So we want to spend a few minutes just talking about some of the contemporary tools that we have that, quite frankly, help us to do our job more safely, but also be more accurate, and then ultimately present demonstratives that you can use in the courtroom or to settle your case in a settlement meeting. So I'm going to talk a little bit about those because these contemporary ones are getting much more cost effective. So here's our original stuff that we have, everything from cameras to measuring tools to, anybody know what that picture is down here? Anybody do premises liability? It's a English XL slip meter. As engineers, we hate slip and falls because, before it was like, it's kind of slippery, hard surface. This thing measures both wet and dry, hard surfaces, and it's not just the coefficient of resistance, it's the slip resistance. So that thing looks like a little heel of a foot, how it would be applied when a person walks, and it measures from 0 to 1, 0.5 being the critical factor. If it's above 0.5, it's not slippery. And oh, by the way, there's a standard for that. So we calibrate the machine, go out and test it, bring our results into the courtroom. Here's a standard, here's our results. It's not slippery. It's great. But if we find it is slippery, we'll tell you that too, and you want to know that. Next slide. So here's some of the more contemporary tools. I'm going to talk a little bit about drones, in-house, off-the-shelf animation software. Before, we would have to get our expert to spend a lot of time educating a graphic designer to paint a picture that counsel may not be able to get admitted because it's not accurate enough, and that's a ton of money. So now by minimizing the graphic artist, we can expedite you getting that animation and its credibility of being what the expert says happened. 3D printing is some cool stuff. I'm going to show you some on that. And then 3D laser scanning. Next slide. Okay, this is, I guess, video number 2. There's a big fire in Harper's Ferry, West Virginia. I guess it's close to 4 or 5 years ago. And we went out there with our drone, and the fire marshal, back then the regulations were pretty strict on who could fly it and what needed to be done in order to do it. If we use a drone, it's for commercial purposes. If you go out in your backyard and are taking pictures of your neighbor, which is creepy, but that's another story, you don't have to have a license for that, okay? So when you're working with an expert that says they have a drone or you think a drone would be helpful, make sure that they've gone through the FAA process. It's not a pilot's license, but there's a process, there's a bit of ground school, and they have to register their flight. Because if not, that could be spoiled and thrown out later on, okay? But obviously the drone can go where things are unsafe, whether it's a fire scene or it's a steep pitched roof where there's claims of hail damage and it's winter. So the drone can be a powerful tool that, again, is a very cost-effective thing that we can just have in our quiver of toolkit. Next, back to the PowerPoint, please. Yeah.
Questions about that. When you talk about they need a FAA cert, and what should we be looking for? Say I've got a plaintiff who sent someone out
Yeah.
to take drone footage of a collapse or something like that.
The actual certification, if my contact information, if you could send me an email, I'll send you exactly what it is, as opposed to.
If you know what to question.
Yeah, exactly.
As far as the footage that
Yeah,
you took.
yeah. So please do send me that, and I'll send you exactly what is required to fly it. 3D laser scanning. Anybody ever use a 3D laser scanner? I'm a Navy guy. We have radar on ships. What does radar do? It shoots a signal out, hits metal, comes back, and it measures that distance. A laser does it more quickly and more accurately. It sends a laser out. So what the 3D laser scanner does is this little gadget here, it's about yay big, sits on a tripod, spins around for about 8 minutes, and captures data points in 3 dimensions, okay? So it's also got a camera built into it, so it'll capture the color, and it will essentially create a 3D model of whatever you're scanning. So if I were to do it in this room, it would create the room. It would not just like, oh, this is just a picture somebody painted or took a picture. This is a 3D model of the evidence or the accident scene, whether it be a roadway accident scene or a tractor trailer that's sitting on the side of the road. So it's pretty powerful stuff because, let's go to the, I think the next slide is, that shows how it works. It captures the information in 3 dimensions, and I think the next one is an example. Yeah, so if you could go to the next video, that'd be great. But the 3D laser scan creates a 3D model, okay? And so what we've done now is we'll go out and scan it, and let's say you're not there with us, and it's a fire scene, okay? It's a very complicated house that's going to be remodeled or changed forever, okay, as you're seeing with this fly-through, okay? So what we do is we scan each room, and then we stitch the scans together. You'll see these little globes in here and little things. They show you that scan 1 ends and now scan 2, so we can put them all together. It's a 3D model that then what we can do is we can send you a web share link. You don't need to have special software anymore. And you can go to it that night, or we can do a go-to meeting and you can see it, what we see on our computer, and we can say, this is the evidence that's zoom in or back out or pan left, pan right. So you can see what we saw, basically. What this fly-through is it says, okay, I want to start at the front door. I want to go down this hallway, up the stairway, and it creates a fly-through of the 3D model. Okay, so this could be a powerful thing for telling the story as a demonstrative piece of evidence in your trial. Okay, or you could just use it because you could say, here's where we're looking at. Let's get in closer. Let's take a measurement. Because it's a 3D model, everything's measurable. The color's accurate because there's a camera built into it. So it looks like a guy's just going through with a camera, but no, this is actually a 3D model that we're saying start here, go there, and end there. And this, to try to animate this, would cost an enormous amount of money. And then again, would it be accurate? Would it get, so when Joe tries to get this admitted into court, the judge is going to go, well, is it accurate? And then that's when our experts can say, well, it's not only accurate, but it's more accurate than me because I took some measurements, and here's what I get. When you use this, it gets it even a smaller number. There's less, there's more accuracy in the measurements. So anyways, the 3D scanner is becoming much less expensive now, and so if you go to conferences, you'll see folks talking about it because it's a tool that you ought to consider if you want to preserve a point in time of the evidence. If you go out to an accident scene 2 years later, it's 2 years later. You're capturing 2 years later's evidence. So getting out there early probably matters. But if you just want to, scan it before it goes away, consider this tool. Yes, question, and back to the PowerPoint, please. Yeah, good question. So if we go out and do a scan, we're going to charge you probably a use fee because these scanners are expensive. So we're going to probably charge you, I think, $750 to use the machine. And then it probably takes another couple hours to do the scan and then to stitch it back together. So roughly, I would say, let's say it's a half-day inspection or something like that. Probably an additional, $1,500 is a ballpark, maybe a little more. It sits on a tripod. No, it sits on a tripod. It spins for 8 minutes, gets 3 dimensions. Then you put it over there. Yeah, you move it. And you set those globes up that it knows where the first scan and the second and third, so you can put them together. And if I don't get to enough detail here, I'll be around certainly after the session and hopefully later on the day too. So, okay. 3D printing, next video. This is cool, and this is the audio clip. CNN does a much better job than me, so I'll let this lady tell us about 3D printing, and then I'll tell you about how it applies to your world. Hopefully it plays.
Traditionally, when you think of printing, you think of printing out something on a piece of paper using ink. Well, 3D printing is actually printing out a physical object. You have a digital image that you can create using different animation modeling softwares. You connect this image with your 3D printer, and it actually takes that, analyzes it, and it prints it out in physical form, layer by layer. If you think about traditional printing, you have syringes with ink. With 3D printing, you can have syringes filled with all different types of liquid consistencies. So this could be plastic, this could be rubber. Some more advanced ones are using metals. Manufacturers have been using 3D printing for decades, and you can print out car parts. Aerospace industry uses this, but also more and more you can print out really creative things. Doctors are printing out prosthetic limbs. You can now print out organs. We spoke to a fashion designer who was able to actually 3D print sunglasses that he put on his models for fashion weeks. It used to be that the average person couldn't own one because 3D printers were really, really expensive. We're talking like $500,000. But
you may
now,
find them in your local
a couple
libraries
different
now
companies came and they said, you know what, we want to make this so average people could have this. You can probably get one for about $1,000. So let's say I had a jacket and I lost my button. Instead of going and trying to go to a store and find a new button, button, I could actually download the blueprint, connect it with my 3D printer, and I could print out a new button. The people at the forefront of this movement, they say they want this to be as common in people's homes as the toaster oven. So you can only imagine that 5-10 years down the road, a lot of folks are going to have 3D printers in their homes. Well, in short, you can't fully print a gun on a 3D printer, but you can print parts of a gun. The idea that this technology is out there and it could be used to print weaponry, to do this kind of stuff, you know, it shouldn't be terrifying, but it is happening, and it's the kind of thing that lawmakers need to understand the technology, not shy away from it, and know that this is coming down the pipeline.
Back to the PowerPoint if we could. So how does this affect your world? Well, certainly from a product liability standpoint, as more and more component parts are printed with a 3D printer and potentially fail, that manufacturing process is going to come into your world. So that's something to consider. Equally important, and I've got a little demonstration for you, is you can take something very large and make it manageably small, or the opposite, something very small. And you can do that accurately. You can do that accurately because when the input to a printer could be a 3D laser scanner, okay? It could be a CAD file, or it could be technical drawings, okay? So as opposed to getting a sculptor out there to give you this 3D print, it's actually done by the evidence itself. And it's accurate, and it can be scaled. So that's really important, again, so Joe can get it admitted into court. Next slide, please. Here's a story of this ship. Has 2 rudders, okay, and she's going into, I think it was Chicago, okay, and one of her rudders fell off. It's a really old ship, so I guess rudders fall off on really old ships sometimes. Next slide. This tugboat's pushing a barge, and she's got her propulsion unit back there, the azopod, and she runs into the submerged rudder, okay? Causes enough damage to take it out of service for quite a bit of time, and that's lost revenues, big time. So what we did is we scanned the azopod and we scanned the rudder, and we were able to 3D print and scale them down. This is on a 1:20 scale, and we brought it into the settlement discussions. So now we were able to take the evidence and bring it into the courtroom environment, if you will, and be able to talk about it at a very inexpensive rate. So just some things to consider with regards to 3D printing. Next slide. I'm not going to show these videos, but the point of the animations versus simulations is, I think in the world of fighting the legal fight, animations can be great to kind of help tell the story, okay? Simulations, actually, why don't you jump ahead and show video number, not the next one in sequence, but the one after it. It shows this is a simulation, which is what a biomechanical engineer will use. So in a simulation like this is Matimo software. We take the design, the structure of the vehicle, we input the force into the program, and the size of the occupant is inside. And then we show here through a simulation as to what they would experience, and then here's the forces measurement on the right-hand side. So the simulation is different from the animation. They both kind of help tell stories, but the simulation is probably more accurate and credible, and counsel will have an easier time getting that admitted into the court proceedings. Okay, back to the PowerPoint, if we could. My point about the animations is now, quite frankly, by having off-the-shelf software that we use, we don't have to go to a graphic artist. So we can create a animation for you, very inexpensively.
So we've talked about some of the types of engineering experts that are out there, the tools that they have to help them, help you, help me. What do we do next? We've talked about how we know whether an expert's needed. What do we do with these experts? There are tools. As a claims adjuster, as an attorney, we use them as tools. As a claims adjuster, you have a lot of skills and tricks of your trade, so to speak, and so do attorneys. The experts, engineering experts, are another tool to use. My recommendation, I think the best thing that I can say, and I started to say it earlier, is to learn from them. Your particular case facts are going to warrant particular experts, right, in particular fields. That particular expert in a particular field is going to have an opinion. Learn his opinion, and don't feel stupid when you don't recognize it or understand what he's saying the first time. Don't give up there. I see it happen much too often at the claims level, and attorneys do it as well. They get their expert. He's their expert. He's going to speak the expertise. We're going to deal with the facts. Well, the expert's talking about the facts. The expert's talking about the facts. So you need to learn those facts. As attorneys, we can't get up there and testify to what we've learned about, right? So what's the point of learning it? So you can use it in your opening statements to convince a jury and alert a jury about what's coming. If you don't understand what you're talking about, you're not going to convey it as well, right? Same thing in closing arguments. Your expert's already testified. You want to be able to kind of regurgitate what he said and say it hopefully as simply as your expert said. That's the end game. We start off with inspections. Can we jump to the next slide, please? We start off with inspections, and we're going to ultimately, if the case goes to trial, end up at trial. But with respect to inspections, this is how you can use your expert. This is how you can learn from your expert. I've broken down inspections, and Gavin talked about it a little bit. Inspections that occur when your expert has the evidence, okay? When he's physically in possession of the evidence. He's at his warehouse. That's the home team. I also talk about an away team when the other team, when the opposing party's expert has possession of the evidence at his warehouse. There's responsibilities incumbent upon both. But it's a good opportunity for attorneys and maybe claims adjusters to go and see that evidence, attend the inspection, stay out of the way. But it's a great opportunity to orient yourselves with the evidence that you're ultimately going to be adjusting a claim or making important decisions about your defense of a claim or your prosecution of a claim. The same thing applies to an attorney. It's hard to argue evidence that you've never seen. And by seeing that evidence, that's going to help you make a better argument. There's protocols with having your own, being the host of an inspection. You're going to have a sign-in sheet. Your expert is going to control what's inspected. What I don't mean by that is your expert's not going to say, no, you can't inspect this. He's going to say, I'm the one who picks it up and puts it on the table. I'm the one who's responsible for rotating it, potentially breaking it or keeping it safe. But your concerns here are fairness and spoliation. You want all parties to have an opportunity to take photographs, to touch the evidence, to look at the evidence, to examine the evidence. And if you're the home team, so to speak, if you have the evidence, you're going to want to place other parties or potential parties on notice that an inspection's taking place. The same thing really applies when you're the away team. The other side has the evidence. I won't spend too much on that. If we can jump ahead again, and one more ahead. Using your expert to prepare you for depositions. Claims adjusters expect this, okay? You want your attorney to use your expert or use his expert as an asset in preparing for depositions, preparing deposition testimony, or knowing the right questions to ask. I spent 25 minutes last week on the phone with an expert, getting questions, sending him my questions that I'm going to ask, okay? But he's the one, I'm deposing the other side's expert. He's the one who knows the real strengths and weaknesses of the case. So you want to get his take on it, and so that you can get the information your expert needs to do the job. Now, the end game in all of this is we talk about inspections, investigations. We talk about discovery, preparing for depositions. If your case is one of those 5 or 10% that go to trial, you also want an expert who can testify, who prepares good written reports and does a good job at the inspections. But you also want an expert who can testify. Very briefly, I had an expert a number of months ago, or about a year ago, and he told me his theory about a case about how a furnace caught fire and safety mechanisms were bypassed, and he told me 3 times. And I asked him questions, and I still didn't understand it. By the 4th and 5th time, I finally learned it, started catching on. But you want that same expert to go to trial and be able to communicate to a jury of lay people. And that's when I spoke about prior working relationships. It's important to keep in touch with your attorney and to have your own working relationships with these experts so that you know who to go to, who's going to do a good job for you, and at the end of the day, help you win your case. Any questions?
I have just one comment to add to what Joe's saying. I mentioned if you call us early, we're not going to, start billing to the thing. Sometimes I think counsel doesn't call us early because the insurance company is saying, don't spend money on experts, which is a disservice because if you have to depose the opposing side's expert, you need to understand what we're thinking. And so, at least at CED, I can speak from our company's perspective, we're happy to entertain that initial consultation free of charge. And so, that goes to lawyers and claims folks. But maybe not everybody's that way, but I suspect in this day and age that they'll certainly give you, 15 minutes of time to kind of help prepare for those depositions you may have. Thank you.
Yeah, thank you, Joe and Gavin. In the 32 years that I've been hiring experts, I've learned a few things that I think we ought to just talk about for a second. And Maurice Delenn is probably the master of this. And the question really is, this stuff is fascinating, and thanks. I mean, that's the 3D scanner stuff and the drones are all really interesting. And part of what I like about my job, and you probably like about your job, is that every day we're figuring out something new and trying to figure out how something happened or how we're going to prove it happened or how we're going to disprove it happened. And that's where we really need the experts. But what does it really come down to with us, mainly you folks? Money, right? You really need to know how much money is at stake in this particular claim or in this case, and how much money do we have to spend to try to get to where we want to get to. So I think the most important thing, or one of the most important things for claims people and for litigation lawyers is to get together, the claims people. If there's no lawyer involved, obviously it's just you, but if there's counsel involved, get together, figure out not only what do we need, but how much do we have to spend on this. And then once you figure out how much you have to spend, and obviously what kind of expert you need, go to the expert and say, I need a what, Maurice? A budget, okay? Every case where you hire an expert, ask for a budget, okay? As lawyers, we hate the B word. Because
As experts, we hate it too, but it's the way it's going,
it's the only way to do business.
Yep.
You have to know how much you can spend. You have to get an expert or experts who will be able to keep you within that budget. You have to get the budget from those experts, and you have to make sure you stay within that budget. Did I say it right, Maurice?
Yeah, but it always doesn't work.
It never works.
Todd, if I can comment there.
Yeah.
So when we're asked to do a budget, whether it's by a claims professional or counsel, we've got a not really sophisticated process, but it's a spreadsheet, and it calls out the typical activities. I showed you an icon of where we see the case going all the way to trial, okay? And we can estimate many of those things: inspection time, travel, review of file material. That can be easily done if we get good information up front. But oftentimes, the case morphs into more. So by preparing this spreadsheet, line item, if you will, of billing, we're creating something that you can hold us accountable to later. And that way, when you say, well, how come the bill's a little more expensive than you said it was going to be? Well, it says here we were only going to be looking at 4 depositions, and you gave us 10. So that equates to more time to review those things. It's good for everybody. So
Right.
asking us for estimates up front is healthy for us in our business.
Yeah, make sure your lawyers are not giving damages depositions to your liability experts. It's all about common sense. And when you get a budget, one of the things that does for you is it gives you the option to pick and choose what you want to do and what you want to not do. For example, there's a lot of triage involved, especially Dick Gray's like doing something in sign language to me.
Time?
I think it means I'm really entertaining him. But anyway, get a budget, and we're going to take a 5-minute break. So let's come back refreshed and ready for the next topic. Thank you, Gavin.
Thank you.
And Joe.